Welcome back for those who have joined us for our first and second week of our panel series. Today, we are excited for our third panel discussion in the panel series, The Role of the United States Sentencing Commission in Decarceration, the First Step Act and Beyond. Today, our panelists will share their thoughts on sentencing review and reduction, looking at open questions and next steps for the United States Sentencing Commission. This panel will cover efforts that the Commission has made to reduce sentencing exposure through amendments to the guidelines, as well as areas the Commission should focus on moving forward. Panelists will outline how changes to the First Step Act have left open questions, and will discuss current initiatives that have expanded release opportunities, such as the Holloway Project, which is being undertaken at Debevoise and Plimpton, a firm in New York City, as well as other compassionate release efforts led by groups like NACDL and FAM. Our rockstar panelists today will discuss ways in which the Commission can further decarceration opportunities through future analysis of the guidelines and policy statements, hearings on the impact of different legislative and guideline changes, and then reports that the Commission might compile to inform future legislation or policy advancements in the federal space. So without further ado, joining us today is Elizabeth Blackwood, Counsel and Director of the First Step Act Resource Center at the National Association of Criminal Defense Lawyers. We are also joined by Marisa, Taney, an associate at Debevoise and Plimpton, and who is lead on the Holloway Project there. And then Cynthia Roseberry, Deputy Director of Policy of the Justice Division of ACLU. Without further ado, let's dive into our panel today. Thank you for being here today. We're fortunate to have such a creative and collaborative group of leaders who have really dedicated their careers to expanding and diversifying responses to federal sentencing through different legislative, advocacy, policy, and litigation efforts. So we're very grateful to you all for your time and insights, and we'll jump right into our conversation today. So we would like to start by asking all of you to share a few of your thoughts and insights around what steps the United States Sentencing Commission has taken in the past to reconsider, review, or address lengthy sentences, and what are some lessons that can be carried forward by the incoming United States Sentencing Commissioners. And maybe we'll start with you, Cynthia, and then pass to Beth and Marisa, if that's all right with you.
Sure. Thank you so much for that kind introduction. And thank you to the Center for Justice and Human Dignity for having me here today. So what we've seen the Commission do is really sort of, in my opinion, lag behind what our evolution in thinking around sentencing is. Although they've been ahead of some legislation like the First Step Act, we've not seen sort of retroactive application of the guidelines across the board. And that's important, coming from a trial lawyer, it's important because it looks like justice when we do this, right? So we want two people who are similarly situated, who are serving time at the same time, to look at each other and know that they got a similar sentence, but without applying evolution in the law retroactively, we don't see that appearance of justice for people. And that has an impact on, a belief in the justice system, and whether or not we believe, that the Sentencing Commission has gotten it right. And of course, the members of the Commission, tend to come from sort of one side of the criminal legal system. And although there's public comment and there's also input from advocates, I think moving forward, it's important to have the direct voices of people who have been incarcerated heard in the decision making, so that we don't just work in data, but that we work, in fact, in human dignity.
I completely agree with Cynthia that the Sentencing Commission has lagged behind societal views on sentencing. But when I look at where the Sentencing Commission has made the most impact over the few years, what I see are the amendments to the drug guidelines. So you sort of see a delayed reaction to, I think, the general consensus in society that the war on drugs was just a terrible mistake and led to just tremendous amount of mass incarceration. So the crack cocaine amendments of 2007, the drugs -2, and the Fair Sentencing Act, which led to the Sentencing Commission changing the guidelines for crack cocaine and powder cocaine disparity. They made a dent in it, and they did help. And they certainly were, I would say they're faster than what Congress has done. But it's really not moving far enough in where we want to be right now with a changing, with the society's changing view on the war on drugs. However, one thing I think is notable is that Sentencing Commission has moved faster than Congress. And we've had 3 years with no Sentencing Commission. And what have we lost in that time that they could have done to correct these egregious sentences during that time period? Because we've really had a void there during that time period.
And Marisa, if we could turn to you next.
Yeah, I'm picking up on what Beth said about the Sentencing Commission moving faster than Congress. I think that's a really important point, because one of the things that we've seen, especially in the post First Step Act, at least in the compassionate release space, is the Sentencing Commission has been able to take a statute and be broad enough in its construction of that there is space for judges and lawyers to advocate on behalf of clients who deserve relief, even if the law doesn't expressly give them a right to get into court through another mechanism. And so I think the importance of the commission paying attention to where those gaps are and acting to try to create space even before Congress does is another really important function they have.
That's fantastic. And thank you for sharing those insights. And I think kind of a common theme, and Cynthia, I just want to kind of raise up what you had said about us not only working in data, but working to promote human dignity and working within human dignity, which I really also think speaks volumes of not just the work that the commission has done in the past, but what the commission can do moving forward to promote both data evaluations, but also what are the policy statements, the amendments, the practices, the training that the United States Sentencing Commission itself can undertake to really advance human dignity, whether or not there are these explicit carve-outs for sentencing review, like you mentioned, Marisa, explicitly stated in the law. But I think kind of that interest and then the groundswell among advocates for really looking towards both the guidelines, but also further guidance and policy statements that are, kind of promoting or accepting or encouraging a sentencing review with an eye towards human dignity, I think really kind of hits the nail on the head. And so, Beth, along those same lines, would you be able to highlight some of the major changes made by the First Step Act of 2018, some of the questions that legislation has raised, both open questions for practitioners, for judges, for justice-involved individuals, and whether or not you think that the United States Sentencing Commission can play a role in addressing some of those open questions, providing guidance or further clarification for those questions.
Sure. The First Step Act was a very broad, far-reaching criminal reform bill that touched on many different aspects of federal sentencing law. So it expanded safety valve. It made the Fair Sentencing Act retroactive to individuals. It allowed individuals who are incarcerated to try to get reduced sentences by taking programming classes. But I think one area where we've seen the impact of the lack of a sentencing commission and the changes of the First Step Act, one of the biggest impacts has been with compassionate release. And so compassionate release is a statute that allows incarcerated individuals to ask district courts for a reduced sentence. And prior to the First Step Act, only the Bureau of Prisons could make those requests. And the problem is that the Bureau of Prisons didn't do it, their job. They really failed in their gatekeeping role. And there was about an average of 24 compassionate release motions filed a year. And as a result, a tremendous number of elderly and terminally ill individuals were dying in prison. And the BOP just was not filing motions on their behalf. So it was in light of that the First Step Act amended the compassionate release statute and allows now incarcerated individuals to file motions directly with their sentencing courts, their district courts, and ask the courts to reduce their sentences by a showing of extraordinary compelling reasons. And so the issue here, and we do have to kind of get in the weeds a little bit to explain why the lack of a sentencing commission has made this such a critical issue. But the extraordinary compelling reasons definition, what the district courts are relying on to reduce these sentences, is not defined in statute. It was delegated to the Sentencing Commission, and the Sentencing Commission described examples of what extraordinary compelling reasons could be in the United States Sentencing Guideline Policy Statement, 1B 1.13. And it gives fairly narrow definitions of what extraordinary compelling reasons can be: terminal illness, serious medical condition, family circumstances, if you're elderly and there are other circumstances. But that policy statement only imagines the Bureau of Prisons filing a motion. It does not apply to defendant filed motions, which the First Step Act allowed. So because of that, there's a conflict between the policy statement and the amended compassionate release statute. And because of that, a number of district courts began to hold that that policy statement and that narrow criteria no longer applies to defendant filed motions. And this was a real sea change in how compassionate release could be used, and was very important during the COVID-19 pandemic because there were a number of individuals who were incredibly vulnerable to illness or death during COVID-19 who would not have been able to get relief, but for the district court's willingness to expand compassionate release. So for example, there are individuals who had serious lung issues. They were being exposed to COVID-19 because being in a prison is really one of the worst places you could possibly be during a highly contagious respiratory disease. And the BOP was not keeping them safe. And the courts now were willing to look at those issues and to determine that there were extraordinary compelling reasons to grant them release. In our project with FAM and NACDL, our compassionate release project, we had 200 people get reduced sentences during the COVID-19 pandemic during the height of it. And as I mentioned before, there was only 24 grants on average prior to the First Step Act. So just there you see a sea change. And the number, if you see the total number nationally, there's been over 4,000 grants since the First Step Act was passed. So there has been a real change in thinking by district courts who are now able to use their full discretion and do what sentencing judges do, which is to look at the totality of circumstances and an individual circumstances and determine if they deserve a lower sentence. And so along with these medical issues, we have people and individuals like Marisa and Judge Gleason through Debevoise and the Holloway Project, who are real pioneers in another angle with compassionate release, where they were asking courts to re-examine the initial draconian sentence that someone had received and look at who the person is today, and also look at how the law has changed and our societal views of offenses have changed, and to recognize that that same person who, if they were sentenced today, would get a much lower sentence. And that has been another path towards a reduced sentence as well, that has been very remarkable. And this has existed during this time where we've been letting sentencing courts to have use their discretion in finding compassionate release.
Thanks so much, Beth. It really kind of lays a strong foundation for what the First Step Act has done, but then some of the open questions that remain. And Marisa, if it works, we would love to turn to you to hear a little bit more about how your project with John Gleason, the Holloway Project, has kind of filled some of the gaps or tried to provide some answers. And we know in light of First Step Act, we've seen different initiatives take off, and some that were already kind of implemented and on the ground before the passage of the First Step Act, but some of these initiatives that were very much enhanced by opportunities within First Step Act legislation. So if you could spend a few minutes describing the Holloway Project and how it has kind of addressed and advocated for different responses to the First Step Act, including sentence review, that is really addressing some of these long, excessive sentences.
Sure. So I think the point that Beth made about the Bureau of Prisons being removed as a gatekeeper in compassionate release through the First Step Act is a really important one here, because not only did putting the BOP in that role reduce the number of compassionate release motions that were filed, but it also artificially constricted the reasons upon which somebody could get compassionate release. So even once these motions were getting to the judges, they were always based on the sort of 3 enumerated age, health, family circumstances reasons, and we're not relying on this catch-all other reasons category that was also expressly included in the policy statement, because that was up to the discretion of the BOP, and the BOP's own policy statement said that they could only file for the first 3 reasons: age, health, and family circumstances. And so after the First Step Act made this long overdue reform to mandatory minimums like the AA51 enhancements, the 924C stacking, but didn't make those retroactive, there was this window through the expanded compassionate release portion of the First Step Act to try to get into court and make these equitable arguments about these sentences and use compassionate release for the other part of what it was intended to be, which was this judicial second look. And I think when you think about compassionate release in that context, it's important to remember that as part of the Comprehensive Crime Control Act, when all of this stuff was getting passed, federal parole was abolished and compassionate release was created. And there was this idea that instead of having this opaque parole commission reviewing federal sentences, we wanted to move that sentencing authority back towards the judiciary, which is where everybody sort of agreed it belonged. But that aspect of compassionate release wasn't really getting utilized because the BOP wasn't filing motions for anything other than these very concrete age, health, and family circumstances. And even then, very rarely. And so I think that was the whole identified by people like Judge Gleason, who, when he was on the bench, was really troubled by these stacked 924C sentences in particular. And this project was created to try to get U.S. attorneys to agree to vacate some of those sentences or some of those charges, so that we could then go back in and get a new sentence from a judge on that. And compassionate release, the amendment to compassionate release through the First Step Act, was this way into court for us, because we had judges who were saying during this U.S. attorney controlled phase of the project, I want to do this, but I don't have the authority to do it unless the government makes a motion. And so now we had this way in. And as Beth highlighted, the big problem here was that the Sentencing Commission's policy statement didn't address motions filed by defendants. And so there was language in that catch-all that said, upon motion of the director of the Bureau of Prisons, or as determined by the director of the Bureau of Prisons, that courts were reading to circumscribe their authority in this respect. And once courts said there is no applicable policy statement to defendant filed motions, and if we use that as guidance, there is a catch-all, so we can consider other things, it really opened the door to try to go into court and let judges do what they were tasked with through the First Step, through the Comprehensive Crime Control Act, and relook at these extraordinarily long sentences. The legislative history supports that was part of the purpose of doing this. And once we did that, these judges were looking at who the people were today, their programming in prison, their conduct in prison, the sort of self-evolution that these people had gone through while they were incarcerated, the efforts they were taking to turn their lives around, the family support they had, the circumstances of their offenses. Many of them were young men of color, because that was how these 924C stacked sentences were often leveraged. And the Sentencing Commission itself had made observations about that racial disparity. And we were now able to bring those things in all together and say, the circumstances of this case never warranted the sentence. But even though the sentence was handed down, to Cynthia's earlier point about the making sentences for similar conduct similar, we were saying you've now created this disparity where for the same conduct today, this person would be sentenced to far less time, and that erodes faith in the justice system. And so I think the consummation of all of those sort of identified issues and this narrow window opening up to let us come in and make these arguments to a sentencing judge, often somebody who had been troubled by the sentence for many years, was a really incredible opportunity for us to try to get some relief for these guys who are sitting in prison for decades for pretty much no reason at this point. And we've so far gotten 34 guys home and shaved off, over 1,100 years of prison time for people who are now thriving in the communities they've gone back into.
Thanks so much for sharing. Thanks so much for sharing a summary. We know we could probably have a whole week of panel series related to the Holloway Project. So we're excited to hear a little bit more at the end of the panel. But Cynthia, we'll turn to you now to hear a little bit more about your experience. We know that you've had such a diverse career, for everything from being a federal defender to managing the Federal Clemency Project during President Obama's term, and then your work at the Justice Roundtable. You've been able to see both from an advocate's perspective, but also from a policy perspective, and now at ACLU from a legislative perspective, what can be done or what needs to be done to address sentencing reform in a more holistic way, and really kind of from the ground up. So we would love to hear a little bit about pieces of legislation that the ACLU is advocating for that might build on or enhance the First Step Act, and how might the Sentencing Commission support these legislative efforts, or kind of the underlying reasons that are justifying some of these legislative pieces, and if there are certain areas of law that the United States Sentencing Commission could really take on and spearhead that would support some of these pieces of legislation.
Thanks for that question. So of course, there's the First Step Implementation Act that would give some life to the First Step Act by reducing the stacking or incorporating the relief from the stacking of mandatory minimum sentences that permits judges also to expand use of the safety valve, for those low-level offenders without a significant criminal history. It just allows the courts to also look at people who committed the offense when they were under the age of 18 and take that into account, and to in fact expunge nonviolent, and I don't like that dichotomy, but nonviolent juvenile delinquency adjudications and other juvenile criminal records. And it also requires the Attorney General, I think this is one of the most important pieces of it, to establish procedures to ensure criminal records exchanged for employment are accurate. And that's so important because the criminal history plays such a significant role in sentencing. And then it's enshrined, right? Once the sentence is handed down and once folks have served their sentences, that is the record that's used. And, Marisa talked about the racial disparity in sentencing. Well, we get these criminal histories from racial disparities in policing and in charging, right, and prosecuting, and, in fact, in sentencing. So the criminal histories, although they can appear to be extensive, can quickly add up when you think about arrests that are made in communities that are significantly policed. So that's kind of, where we are on the First Step Implementation Act. The ACLU is also leaning in on the MORE Act, which would deschedule marijuana, but it has a social justice aspect of it too, to try to provide some reprieve for folks who are victims of the war on drugs with expungements and access to a small business association assistance in establishing their own legitimate cannabis business. So that's a very important part of that redress. We're also leaning into the Equal Act, which would take away the disparity between crack and powder cocaine and because there's no significant chemical difference between those two drugs, make sentencing equal for those. And, if I had my dream, it would also be prohibiting, use of acquitted conduct in sentencing. That Punishment of Acquitted Conduct Act of 2021 would allow the judges to disregard, right, or instruct them and encourage them to disregard issues that have been passed on and have been found to be unsubstantiated as an enhancement for sentencing. So not punishing conduct that was in the past acquitted. So I think those are the major things that we're leaning into right now. Of course, we'd love to see a robust second look provision for people who, especially the so-called old law people who aren't entitled to parole. And then because, compassionate release is one of those only vehicles, having a second look. And I'd just like to, kind of comment on what Beth and Marisa said about this compassionate release. It's especially important during this time of COVID because what happened with the BOP not filing motions for compassionate release during COVID, or not having a robust motion filing activity, what they did to segregate people was to increase solitary confinement. So to increase punishment for people because of this pandemic. So I just wanted to put that little tag onto the end of that thought.
Thank you for that, that point, and a lot to unpack there. And I think what especially stood out to me in your response is beyond us looking at federal sentencing reform in the typical way where we're looking at sentencing review, and second chances, and the judge's ability to relook or resentence an individual. Your notes about supporting different legislation that really looks at sentencing reform in a much more holistic way. So post-release sentencing opportunities or sentencing reform opportunities, such that if a legislative agenda is looking at educational opportunities, job opportunities, licensing opportunities, providing clean slate, and really working to reduce the impact of a criminal history, that those are all factors that we as practitioners and reformers should be keeping in mind, that yes, prosecutors and defenders and judges are playing a major role in sentencing review and reduction, but that there are opportunities then at the back end to address maybe some of the harms that have already been done by excessive sentences. So I think that's a really great thing for us to keep in mind. And I'm sure we'll touch on that a little bit in our next question. So again, we would love for all of our speakers to address this. And Marisa, maybe we'll start with you. We'd like to kind of ask the broad and open-ended question around how you would like to see the United States Sentencing Commission, as commissioners are appointed in the next few months, how the Sentencing Commission can use its authority moving forward, and possibly expanding kind of beyond the bounds of the role that the Sentencing Commission played in the past. So Marisa, we'll start with you, and then we'll go to Beth, and then last but not least, we'll go to Cynthia.
Sure. So, I think going back to this idea that there is a gap to be filled by the Sentencing Commission between, what we all understand perhaps should be reform that is needed and the legislature catching up. There's this idea also that the courts oftentimes will wait on the commission to fill that void. And so I think particularly in the compassionate release space, and I think both Beth and Cynthia could speak to this in other contexts and in that context as well. But there's this idea that the courts are first looking to the policy statement to say, are we bound by this? Is this a requirement? Is this some sort of restraint on how much discretion we can use based on our sort of sitting here in front of a human being and evaluating who this person is and who they were when they committed these offenses? And the commission has said that they need to promulgate a new policy statement for defendant-filed compassionate release motions. I think that's a really easy opportunity for them to make sure that the maintenance of that sort of band of judicial discretion is codified in that policy statement, so that there's no more debates about what judges can or cannot do within the broad discretion they've been given by the statute and by Congress through that statute. But I also think there are certain courts, including the Supreme Court, that are waiting to see what the commission is going to do, and their basis for not taking up many of these issues is, well, the Sentencing Commission hasn't weighed in, the Sentencing Commission hasn't spoken. And so I think an awareness of sort of the interaction, not only between the legislature and the commission, but also the courts and the commission is really important so that they can continue to move the ball forward in the right direction. The other thing, and this goes back to, Cynthia's original comment about, not working in data, but in human dignity, there is also a crossover between those two things where the commission taking up certain questions about how these laws have been applied and how they affect criminal defendants is really important because, routinely when we're making arguments about this racial disparity and the way 924C was leveraged, the source for that is the commission's own data. And they are often in a position where they can have access to that data and dedicate resources to evaluating that data in a way that sheds light on these important areas of disparity within the criminal justice system. And so I think using data to shine a light on the areas where we're not being as mindful of the human dignity element is also a really important role of the commission.
That's a really good point about the Supreme Court waiting on the Sentencing Commission to rule on a lot of these issues. And just to get a little bit background on that, during the 3 years that we've had no sentencing commission, and there's the First Step Act and a lot of complications about sentencing guidelines in relation to it, there's been a tremendous amount of litigation now over these discrepancies between the First Step Act and the guidelines. And we have circuit splits in all sorts of issues, not just compassionate release, where we have some significant circuit splits, but also with safety valve. There's some really interesting issues going on with that as well. So it's going to be really interesting to see how the Sentencing Commission deals with fixing these guidelines and these policy statements now with this litigation ongoing, and then what the Supreme Court might do if the Sentencing Commission comes down one way or the other. And I think it's going to, and we've seen this, the Supreme Court typically trying to defer to the Sentencing Commission. But one thing that's curious is that with Justice Breyer gone, who is really the architect of a lot of the sentencing guidelines, will the Supreme Court now be more willing to take up these issues and to definitively decide things one way or the other when there are these difficult issues and these circuit splits that have arisen during this time period? So that's something that I'm really interested to see, and I think where there's more litigation in our future, one way or the other, with however the Sentencing Commission decides to rule. But I know from my perspective, and from I think anyone who practices in the criminal defense and the criminal reform world, the hope is certainly that with regard to the 1B 1.13 policy statement, that the Sentencing Commission will give the benefit of the doubt to sentencing judges. It will allow them to use their discretion, honed from years of making difficult decisions and looking at the individualized context of criminal defendants, and let them have the ability to make the correct determinations as to what a sentence should be and if a sentence should be reduced. It's not an end run around anything. It's just allowing sentencing judges to do what they always do, and to have a great deal of discretion to make decisions. So that's certainly my hope with regard to what the future is of 1B 1.13.
So if I had to dream about this, I certainly appreciate the forward look of what the judges will do and what the courts will do, the Supreme Court will do. I think the commission has the ability to affect downline as well. For example, because it develops policy, one policy could be that in order to have sound legislation, in order to have sound sentencing, that there be a sort of environmental impact statement or prosecution impact statement, so that we understand how, when this legislation is passed, the impact will inure or will go out to the folks who will ultimately be prosecuted, and how it will embolden or empower prosecutors, right, to charge people moving forward. I think about the trial penalty that we all know about, that's not discussed. That is, if you choose to go to trial, your sentence is likely to be longer. The use of obstruction of justice in trials, when a person who's charged with a crime decides to take the stand, the commission could have an opinion about that, or develop a policy about that. There could be a better definition of recidivism, right? Because we know that people have contact with the criminal legal system and are called recidivists for things that aren't really criminal actions, right? I know this is a laundry list, but I'm dreaming here. I think about the use of the 5K departure, and how there needs to be more of an indicia of reliability, because prosecutors have this broad discretion to use it. And also the broad discretion to, although judges make the determination, to say that someone has accepted responsibility. And then here's my pet peeve, that when we look in section 5 of the guidelines, 5H, the commission talks about being neutral with respect to race and gender and creed and socioeconomic status, these sorts of things. But when you look through 5H, those things, education, for example, can be used to enhance a sentence, but not decrease. Family ties can be used. Well, loss of caretaker can be used to decrease a sentence, but dependence on criminal activity can be used to increase a sentence. For example, lack of guidance as a youth is not used, right? And so, I've already talked about over policing that can increase criminal histories, but then the commission tracks these very factors, and you have to wonder why, right? If they're not useful in sentencing, then they're not useful to help us discern what happened in sentencing. And so I think it really tells us that we should begin to open up, this commission should open this up so that judges can make a more individualized decision based on the real world and what really happens in prosecution.
Well, I think all of those suggestions, recommendations really kind of chart a blueprint that we're certainly hopeful that the commission will take up. And just to kind of bring things full circle, Cynthia, on your point about other sections within federal sentencing law, I know for those of us who joined us on our first panel, our federal alternative to incarceration panel, where we had judges who are running very robust and more formal federal ATI programs. They were kind of making the argument on the other side of the coin, Cynthia, that if we are looking at things like Section 5.8 around specific offender characteristics, can we be using that in a positive way to think through what are sentencing alternatives or opportunities that if we are looking at specific characteristics, circumstances, life experiences of the individual before the court, how can that specific recognition of these characteristics be used to inform a mental health treatment plan, a substance use treatment plan, and really look at the person as an individual. And so I do think that while we're creating a laundry list and some of these proposals may not be accepted, I think it's certainly given our audience and decision makers a lot to think about. So we're going to end there so that we have some time for question and answers from our audience members, but really want to thank you all for your time and insights. I've certainly learned a lot today, so thank you for being with us all.
Hi, thank you. Rachel Vanneton here with the Center for Justice and Human Dignity. Thank you to our panelists who are with us today. We have some questions from our audience. So I will go ahead and see if we can get through a couple of these. So, the question came up whether sentencing judges can practically revisit original sentences, especially given a deluge of less meritorious. Isn't there a need for recreation of parole boards? This would have huge benefits in incentivizing good conduct within institutions. So I guess
I know there has been some discussion about reinstituting parole. Parole has been banned in federal courts, so that's not available anymore. I don't think anyone wants to revisit the previous version of parole and the old law prisoners it's created that seem to be perpetually stuck in this cycle, and it's very difficult to get out in some situations, but it would take a lot of work. I know there was some momentum a couple years ago to revisit parole, and perhaps that is something down the road that would be considered. I think we have to learn from the lessons of the past and a lot of the difficulties that there were with parole to reinstitute it. But it's certainly been in the conversation in the criminal reform world. I'm not an expert in it because the parole world happened before I was a assistant federal defender, but I do know there have been discussions about it.
Thank you. And Marisa, any additional comments?
No, I mean, I think I would agree with Beth for the most part. I think anybody who does compassionate release motions would acknowledge that there are frustrating discrepancies between judges, but I think that on the whole, that probably pales in comparison to the frustrating discrepancies you get from a parole board.
And I also think that that runs the risk of shifting the decision-making authority back towards the BOP and institutions outside of the judiciary, which I think, to Beth's point earlier about learning from the history of the use of parole boards, has not been a particularly effective way at ensuring that we're getting as many second looks for meritorious potential sentence reductions as we could.
Well, thank you. And our next question here is, a number of federal circuit courts have now rejected using the First Step Act to modify sentences that were based on changed sentencing statutes and rules, but not retroactively. Have any federal circuit courts upheld its use for this purpose?
So I'm happy to jump in here. The short answer is yes. I think the way through this pro bono project that I helped Judge Gleason run at Debevoise, we have cases all over the country. And so the way that we tend to categorize the circuits are circuits that have said that the Sentencing Commission's policy statement is not binding, which is the first threshold question. And that's every circuit that has weighed in except for the 11th right now. But once you get to the point where the circuits have said there is no applicable policy statement and district court judges, sentencing judges have broad authority to decide what the appropriate grounds for a sentence reduction might be, there is another circuit split on which you have the 4th Circuit, the 10th Circuit, and the 1st Circuit now. The 1st Circuit was the most recent to make this decision in a case called Ruvalcaba. And they have said, yes, district courts may rely on non-retroactive changes to mandatory minimums and the case as a whole in deciding whether compassionate release is appropriate. On the other side, you have the 3rd Circuit, the 7th Circuit, and the 8th Circuit that have said, no, you can't do that. And then you have the 6th Circuit, which has really gone back and forth and been very internally inconsistent, in most recently in cases called McCall and McKinney. But before that, there were a number of other cases that dealt with this issue and disagreed internally about whether what they thought the first binding decision out of their circuit was. So the 6th Circuit is still flip-flopping and up in the air, but that's basically where we stand. And then you have circuits like the 2nd Circuit that have said judges can consider the extraordinary length of a sentence and a judge's disagreement with that, but haven't expressly tied that to changes in mandatory minimums. Beth, I don't know if you have anything to add on that.
Yeah, it's thorough. It's all over the place. I typically consider it fair game in the 3rd, 7th, 8th. And as the 6th is crazy, as Marisa has discussed, but I typically consider it fair game in any circuit other, in 11th, of course, any circuit other than the 3rd, 7th, 8th, and 11th, to at least try and see if you can pursue a compassionate release motion based on non-retroactive changes in the law.
And I will say, even in the undecided circuits, there are a lot of district court cases that you can often sort of pull up and give to judges that give them some comfort that they wouldn't be going out on a limb or be the only judge in that circuit to make that decision. So I think that's also a useful tool in the circuits that haven't said yes or no at the appellate court level.
Thank you both. And another question just posed to us here: is there a process pre-release to alter the way a releasing prisoner's sentence is recorded to give them the best chance for success upon release and re-entry? If not, is there something concrete that can be done to help prisoners after the fact?
So basically, is there a process? I'm trying to make sure I understand this question.
Is there a process pre-release to alter the way releasing prisoners' sentence is recorded to give them the best chance for success upon release and re-entry?
You can't alter the judgment, although there is a release. There's an order in the compassionate release motion. So perhaps the question is whether or not there's a way to modify supervised release conditions to make them less restrictive. And I that is possible. And I have seen motions sometimes asking for modifications of supervised release conditions because things very, very much might have changed for the client while they've been incarcerated. They might, they might have just a different situation with the ability to work, because oftentimes there's conditions of supervised release where you're expected to work. If they're very sick or older, that might not be a possibility. And if you can't get that changed in the judgment, that's something that often can be fixed once the individual is released while they're on supervised release by connecting with their probation officer. So I guess if the question is everything fixed in stone to when they were sentenced, in 1995 to when they potentially get a release order in 2022, then yes, you really do have flexibility to try to alter the original judgment so that they won't be violated immediately when they get released. And probation officers are usually they're very helpful in my experience to making sure that your client isn't set up to fail when they're released, if that's the question that was I'm trying to do, but I was trying to understand that the best I could.
Yeah, I think that's a really helpful response, and I think I hope that answers the question here. And I don't know, Marisa, if you had any further comments as well, but
no, I think so. The way that we've seen this happen, and I'm sure Beth has had a similar experience in the many compassionate release cases that they've handled through the NACDL, but some judges will release our clients by reducing their sentence to time served, in which case it's sort of a scramble and a surprise to everybody. And sometimes judges will say, I'm going to reduce their sentence, but give them 1 year left to serve, because the judges often feel like they want them to have certain types of programming. Our view is that that's not usually a helpful pre-release requirement, and that there are a lot of ways in which, especially for clients who do still have family support systems, which is a big if, and connecting them with reentry services once they are released can help them sort of acclimate, because many of these compassionate release clients have been in for a very, very, very long time. And so there are a lot of groups, including through, organizations like FAM or the NACDL, that will have connections to reentry organizations. And Beth and I have actually worked on a number of cases together where her organization's been very helpful in doing that.
thank you. A question here, what sort of pressure, what sort of pressure is the USSC, the United States Sentencing Commission, under now that a quorum may have been reached? And from your perspectives, what can we expect, or what do you anticipate from the commission in the near future?
Right. Well, there just been there've just been nominees to the Sentencing Commission so far. They haven't been appointed to the commission. So I don't know when that's going to be happening, hopefully soon. But there's been a full slate of nominees made, and the hope is that there'll be a sentencing commission soon. And yes, they, because there has been no quorum for, 3 years, there is a lot to be done. Not just, there's certainly a lot to be done with aligning the First Step Act to discrepancies with the guidelines, but a number of issues as well. So I think I could speak for myself to say that I'm pretty happy with the slate of nominees. There's Judge Gleason from Debevoise. There's Laura May from the Federal Defenders. There is Judge Restrepo, who's a former assistant federal defender. So there's some really good folks who I think understand the position of sentencing reform, and then also some conservatives as well, but some, Judge Boone from the Eastern District of Kentucky, who I know has granted some compassionate release motions, and I have heard really good things about as well. So I think it's a good, thoughtful group of commissioners coming in. And it's, as far as what our organizations are doing, there's protocol where we send letters. There's just sort of administrative things that different organizations do as the appointments are happening, to try to help, for our organizations to try to help shape the narrative in a way that benefits criminal defendants. So yeah, it's exciting. We've been waiting for this for a long time. I've heard that there's speculation that Senate leadership was consulted before these nominees were presented, which hopefully suggests that they'll get through and there won't be too much controversy, but we don't know. But yeah, there's all speculation on my part, but it's exciting. And I think there'll be a lot of big changes to the guidelines.
Thanks, Beth. Marisa, any other thoughts around the nominations at this point, or the potential path there?
I think I'm too biased to comment on the nominations to the Sentencing Commission.
All right, well, let's go ahead with a question kind of back on kind of these differences in the various circuits on the First Step Act. And the question posed, are there any prospects perhaps that you know of or thoughts around that for a grant of cert by the Supreme Court, given the circuit split on the use of the First Step Act for what would now be void guidelines?
No, the answer is no. I mean, I think there have been a lot of, I mean, Marisa knows more about this than even I, but I think that the Supreme Court has made it fairly clear that they don't want to weigh in on issues that can be resolved by the Sentencing Commission. And there, I mean, it's been really direct, I think, by Sotomayor and Judge Barrett that they are waiting, like the rest of us, for the Sentencing Commission to clarify a lot of these discrepancies. And there's been so many cert petitions on the circuit split, and Debevoise had a really fabulous one of actually a few of them, and the Supreme Court has not picked any of them up. But I don't know. I mean, we're expecting to have a resolution in a crack retroactivity cert case, Concepcion, and that's kind of different than this topic. So that one's going to be resolved, but that's more of a statutory issue in some ways. But I don't expect to see anything from the Supreme Court on the compassionate release issues.
Yeah, I think that the Supreme Court has taken the view that this can be resolved by the Sentencing Commission. I think there is reasonable minds could differ, and I think at least the existence of the circuit split highlights the potential problem with the suggestion that the Sentencing Commission could resolve this issue. And by that, I mean in the circuits where the circuit court has said there is no applicable policy statement, so we're not interpreting the Sentencing Commission's instructions. We are interpreting the language of the statute, and the language of the statute prohibits judges from granting compassionate release based on these non-retroactive or not fully retroactive changes to statutory mandatory minimums. That statutory interpretation is going to remain even if the Sentencing Commission expands the current policy statement to include motions by criminal defendants or leaves in a catch-all in whatever policy statement they promulgate for motions that are being filed by criminal defendants. And so I think the Supreme Court sees this as something that can be resolved by the Commission. And I do think the Commission has said as much, that they need to amend 1B1.13 in the guidelines to reflect the fact that there's now an additional movement who can file these types of motions. But putting that aside, our position is, and I think it's fair given how the circuit court decisions have been written, that the Sentencing Commission fixing the policy statement is not actually going to fix the statutory interpretation problem that is actually prohibiting courts right now from having the authority to decide compassionate release motions on that ground. So,
yeah. And just a question kind of for you, Beth. What sort of specific work is NACDL and the First Step Act Resource Center hoping to accomplish in the coming months and year?
Well, I think we are sort of trying to focus on as many compassionate release motions that we can in the current state of the law that we have. So we're focusing on a lot of terminal illness cases, medical issue cases. There's still quite a few coming in, people getting diagnosis of stage 4 cancer. And we really try to step in immediately and provide counsel for those individuals and provide resources for pro bono attorneys who are handling those cases. So we're looking for volunteers always so that we can train, and we're trying to just be a place for these folks to go to in these times of great stress and difficulty for their families. And then, we also are working on the non-retroactive changes in the law cases, Stack 924Cs, A51s. We handle those as well. And there are always ones popping up every once in a while in districts that you don't expect. So we are still just, trudging away with the these types of cases. And there's a lot of work we're doing as well with pattern and the return time credit rules. It's sort of a very different issue, but First Step Act's got a lot of moving parts, a lot of different areas. And one of these are the back end reforms that allow prisoners to get early release from prison by taking programming if they have a low enough risk assessment score. So that is something we're involved in as well as trying to shape the policy, the different issues involving that. So those are sort of the big issues we're involved with right now.
Thank you. That's some exciting prospects ahead. And, you know, turning to you, Beth, to Marisa, how, if you can share some thoughts about how the USSC nominations could impact the goals and strategies at the Holloway Project, or I'd love to just kind of hear a little bit if you have thoughts on that.
I'm going to punt that one to Beth.
I mean, that's really there. I mean, it's going to be really interesting to see how the policy statement is amended. I mean, our hope is that the policy statement is amended in a way that continues to allow district courts to use their discretion to make the correct decision in these types of cases. But then, of course, there's going to be having to reconcile that with some of the circuit case law that's come out, which Marisa talked about so eloquently. So there will very likely be a lot of litigation as well. And that's fine. But I think, the hope is just the policy statement will be amended in a way, like, as I said, that doesn't just curtail district courts to this very narrow criteria, which is what existed pre-First Step Act. It's very limiting, and I think a lot of folks who are deserving of relief miss out on the opportunity to get relief when you have such a narrow rating. And this has been a really good time, and I think one of the important parts of this period where we've had this gray area where the policy statement hasn't been binding on district courts for so long is that we've seen the district courts are able to do what they've always done, which is to look at the facts, look at the situation, look at the individual before them today and make the correct determination about the sentence or lack thereof that they deserve at the time. So it's really just allowing sentencing courts to do what they're always good at, which is to find the correct punishment and determine when punishment has been met as well in cases. And so it's been a wonderful experiment, and I think should give the Sentencing Commission the confidence to allow the district courts to continue to have a great deal of discretion in these cases.
Yeah, and I won't connect it directly to the Holloway Project, but I do think that one of the things that the courts have consistently looked to for guidance in trying to decide how they should be interpreting these statutes is any and all statements that have been made or policy statements that have been issued by the commission. And so I do think there's an opportunity in the compassionate release space and the First Step Act space more broadly for the commission to give useful guidance that will make the courts feel like they are making fewer incursions onto domain in which they feel very uncomfortable, and that can place these squarely within the judicial branch in a way that I think will give the courts some comfort in making decisions that they think are appropriate based on the statutory text itself.
Well, thank you both. I think that has covered most of the questions that we've had here today. I want to thank both of you for being a part of this panel, and of course Cynthia as well, who wasn't able to make it for our live Q&A. And thank you to Caitlin, who is our incredible was our moderator earlier on. Just to share with our audience here, our final session around the U.S. Sentencing Commission is taking place next week at the same time on Tuesday, the 24th. We are going to be joined by Judge Patty Saris, Judge Ricardo Hinojosa, retired Judge Nance Gertner, and Judge William Sessions to discuss and learn from the past commission leadership. So we're excited for that conversation as well. And just wanted to thank everyone here for their time and interest in this even more important topic than ever, now that we've got some nominations on the slate, and looking forward to next week. Thank you very much.
Bye.
Thank you.